So that's the kind of Section 43 element of Zalewski, right? It's very, very technical, and it's covered in the O'Donnell judgment really, really well, right? The idea that the district court was being kind of used by, I suppose, ultimately by the legislators in a sense, right, for its enforcement power, but really how in practice, it was the WRC that really had all the decision-making authority. Once the WRC made its decision, that was kind of the end of the matter. And the implication is, if you look at if you go back and you look at the McDonald test, now, of course, we looked at this last week. This is from the Greyhound case, right? The MacDonald and Borden case from 1965, which was a totally run-of-the-mill case, like lots of these cases are that become landmark cases. They're landmarked for kind of random enough reasons. So this is the Greyhound trainer, the Greyhound Industry Act, I think 1958. A certain provision of that gives Borden, which is like the equivalent of the WRC in the context. It is the Greyhound Board, we'd call it, the authority to basically exclude people from Greyhound tracks and basically from the industry for a period of time, or maybe indefinitely, I'm not sure. Anyway, this guy, I think his name was David MacDonald, was obviously a Greyhound trainer, and there was some abnormalities, shall we say, and there was a hearing, and the hearing went badly for him. There was a finding against him. I think he was excluded from Greyhound tracks and sales of greyhounds and so on I think it could have been for a 2 or a 3 year period. And his lawyer is clever and says, well, look, the Board of Gone is doing what a court should do under Article 34. And he actually wins in the High Court. But the reason the High Court judgment is important is because the Judge Kenny, gives us a new test, right? Which I know we looked at last week. And he says basically, look, here are the 5 characteristic features, he says, of quote unquote the administration of justice. In other words, here is the test for Article 34.1. Now, the idea here about the McDonald test, guys, is, here's 5 characteristics. It has to tick each box. Right? If it doesn't tick any one of the 5, then it does not count as the administration of justice, right? It has to satisfy all 5. Now, you look at them and you say, well, okay, they all kind of run into one another. They almost all seem the same as one another, perhaps except for the last one, the 5th, right? So first of all, he says, this is Judge Kenny, it seems to me that the administration of justice has these characteristic features. 1, a dispute or controversy as to the existence of legal rights or a violation of the law. There's a dispute between 2 people, me and you, or you and the state, or you and your employer, or whatever. Is there a disagreement, a dispute between the 2 parties as to the existence of legal rights or whether there's been a violation of the law or whatever? Obviously, that's something that is right at the heart of this concept, the administration of justice. 2, the determination, right? In other words, this process, this body, this actor makes a determination, right? Or ascertainment of the rights of the parties, or the imposition of liabilities, or the infliction of a penalty. So that's another feature. 3, I'm not going to repeat it because it's basically a repetition, it seems to me. I don't see the difference between the 2nd and the 3rd. Right? Okay, so they all run into one another. There's a dispute about the law, and there's a determination of that dispute. The 4th one, I suppose, is something a little bit new, like, the enforcement power, right? So if 2 of you in class are having a disagreement someday, and I, as your lecturer, you guys say we're having a disagreement, she took my, laptop or whatever the hell, and I say, well, I'm going to make this determination. It's actually hers, and I'm ordering you to agree that it shall remain hers. You're going to say, well, that doesn't mean anything to us. You don't have that authority. You're just a person who happens to be standing by. So, but a court is different, as Enoch Burke, sorry, is finding out these days. A court is different. A court in a constitutional state or in a functioning democracy, courts have that authority, the enforcement authority. Now, sometimes, of course, they do have to call in, as it says here, look at it there, the enforcement of those rights or liabilities or the imposition of a penalty by a court or by the executive power of the state, which is called in by the court to enforce its judgment. Now, that's what's happening in the Enoch Burke, the school, not our case, Elijah, which is a much more important case, actually, about executive power, but the Enoch Burke case, which is the one in Westmeath, in the school, St. Wilson's School, where he's ignoring the contempt of court order, you know, and the court basically is called in the executive to haul this guy off to prison, you know, because he's in contempt of court. So the court does have that enforcement authority, even though it has to call on the government. And the fifth is something new, but this goes back then to the Zalewski case, because the state's lawyers, in other words, the lawyers representing the WRC, they argue before the High Court. They say, look, if you look at Section 43 of the Workplace Relations Act, that does not satisfy the fourth limb of the McDonald test. And of course, the McDonald and Bordner-Gon test, they say, is the established test. It's recognized since 1965 for the last, in other words, what is it, 60 years, as the test in this country for what does or doesn't count as the administration of justice. And we're saying that the WRC doesn't have that enforcement power. It's the district court has the enforcement power. And basically, Judge Simons in the High Court agreed. Now, as we said last week, he hesitated, but he said, look, okay, yeah, strictly speaking, you're right. Right? The Supreme Court judges all say no. I mean, in practice, in effect, the WRC does have that enforcement power. So this does not disqualify it from counting as the administration of justice, right? And then, so there was this kind of over and back. Well, does it or doesn't it count? Is this or is this? Does it or does it not satisfy the fourth limb? And there was a similar row, or sorry, I should say disagreement, about the history limb. Now, this guys is important for the broader implications of Zalewski. Again, there's something really technical about it, right? Basically, lawyers for the WRC, they said this process does not satisfy the history limb. Lawyers for Mr. Zalewski said this process does satisfy the history limb. So look at the history limb. The making of an order by the court, which as a matter of history is an order characteristic of courts in this country. Now, in a sense, I suppose, Judge Kenny includes that. That was something new in 1965. That had not been there previously. Judge Kenny actually plucked it from an Australian source, and it became one of the five limbs. And I suppose the idea here, in fairness, if you think about it, is, well, this is 1965, the Greyhound case. And basically, I suppose it says, well, if something has been done historically by courts, then that tends to indicate that it counts as, or ought to count as, the administration of justice for the purpose of Article 34, Section 1. But, you know, every box has to be ticked, each of the five. And I suppose if you think about it, we were looking last week, weren't we, at, we looked at our examples last week. Do you remember the discussion document I gave you where we had 3 or 4 scenarios, the horse racing scenario? But one of the scenarios was the, how should I describe it? The, I guess, sharing images online without the consent of the person. Now, as you all know, that's a criminal offense in this country, as you know, right? But I was painting the picture of a scenario where it was actually designated not a criminal offense, right? But it was civil in nature, right? A civil harassment tribunal and all that. That's the scenario. Now, that was something that I suppose if you look at that in one way, that, whatever that is, that process of assessing whether or not somebody has done that in a particular case, that was not done by the courts in 1965 because there was no such thing as sharing online images online without the consent of somebody, because there was no such thing as the internet in 1965. So I suppose, in a sense, what I was trying to get at there was, well, that wouldn't satisfy the history limb. And in a sense, I suppose, when we see it in a moment, as we will, that is kind of what O'Donnell was getting at when he said, there's something problematic about this history limb, because it means that something can escape the designation of the administration of justice because it wasn't something that was done by courts in 1965. And let's say in 2065 or in 2085 or in 3025, you know, there's going to be stuff happening in the world that we can't even imagine right now. But maybe it's the kind of thing that, because of various kind of features of it or characteristics of it, should count as the administration of justice. That's precisely the kind of thing that should, we think, count as the administration of justice. It walks and talks and quacks like the administration of justice. And yet now it escapes designation because of the history limb, right? So that's, I suppose I'm just bringing your attention to the history limb. Now, I don't think I'll say a whole lot more about it. But you guys, when you read the O'Donnell judgment, absolutely you need to get your head around the arguments in respect of it. When you read the MacMenamin dissent, you need to bring your minds to it, is what I'm saying, right? So let me just show you the slide that I have on it from the O'Donnell judgment. What does he say about it? Oh yeah, he says, viewed and applied narrowly, the history limb, that is of the MacDonald and Boardnagon test, has the effect of confining judicial power to the areas of the traditional causes of action and proceedings and fossilizing the administration of justice in the form of the business of the courts in the mid-20th century. Fossilizing the administration of justice in the form of the business of the courts, in other words, in 1965 when MacDonald and Boardnagon was decided. And then he says the novelty of any new provision, right, in such and such a piece of legislation passed in 2065 or 2085 or 3025 or whatever, which is, after all, the raison d'etre of any new scheme, the reason, the purpose for introducing any new legislative scheme, becomes a shield against challenge, no matter how completely the provision might fit the preceding limbs of the test, no matter how completely the provision in question might fit limbs 1, 2, 3, and 4. So it might walk like the administration of justice, talk like the administration of justice, and quack like the administration of justice, but it might escape that designation just because of the novelty of the scheme. And so O'Donnell kind of says, look, no, essentially he says we're moving on from the MacDonald test. Now he doesn't quite say that, but kind of says that. Now, I'm not actually going to spend time on this because you remember I was talking about the enforcement aspect of Zalewski. Also, there was an argument about the history limb. Like I said to you, Zalewski's lawyers said, what did they say? They said this, oh, this always bamboozles me. This does count as the administration of justice. This does satisfy the history limb. Yes, the state's lawyers obviously argued the opposite. And that was a really technical argument, right? Because the Workplace Relations Act 2015 introduced this new thing called unfair dismissal, right? Whereas historically, the common law courts, which would have been doing this work, I suppose, in the early part of the 20th century, the old common law grievance was of wrongful dismissal. So the lawyers for the state said, well, look, there actually is a difference. The courts, historically, they did this thing called wrongful dismissal. This is a new thing. This is unfair dismissal, right? It's a new jurisdiction. So then there was this debate as to whether, and also incidentally, as we mentioned, that order of reinstatement, which under the Workplace Relations Act, the WRC has the power to reinstate a sacked employee, right? And that was something that was never historically part of the jurisdiction of the High Court, right? So lawyers for the state said, for the WRC, they said, look, that was something that the courts never did. This is something new. And so it doesn't satisfy the history limb. And so it doesn't qualify as the administration of justice. And so Zalewski should lose his case. But O'Donnell and his colleagues in the majority were kind of saying, well, look, this is bamboozling. what's the difference between wrongful dismissal and unfair dismissal? Yeah, if you look at it very, 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 very forensically and closely, I suppose you can see there's a difference, but basically it seems to be the same. Do you know? And similarly with the enforcement thing, yeah, you could argue that it's the district court that does the enforcing. You could argue it's the WRC. It's bamboozling. It's so he says, what O'Donnell says is, you know what this tells us? It tells us that the Greyhound test, the MacDonald and Bourne-Nagan test, is not actually very helpful, because it's like everyone is taking it like a checklist. You know, he says the treatment of the criteria in MacDonald as a checklist, which must be minutely and precisely complied with, risks missing the wood from the trees. Right? It's a really simple phrase, a colloquial phrase, but it captures what O'Donnell feels is problematic about this approach that has been taken to Article 34 for decades. Right? Treating the 5 criteria as a checklist, which must be minutely and precisely complied with, risks missing the wood from the trees. That, you know, when you're up really close, yeah, okay, it doesn't qualify as, but if you step back, basically it does. Okay, it also encourages an approach to drafting legislation, right? Do you see what he's getting at there? It also encourages an approach to drafting legislation that could remove proceedings from the field of the administration of justice because of some small and in truth insignificant deviation from the checklist. That would be a triumph of form over substance. And what he's getting at there is that the drafters of legislation, obviously it's not the legislators themselves, that they are members of the Oireachtas who are drafting it. It's clever lawyers, right? The policy is delivered by the legislators, and that's appropriate. They say, look, this is what we want. Draw us up a workplace relations commission that does this. Okay. But the drafters say, okay, well, let's be clever. Let's take the enforcement limb of the MacDonald test. Now, is there any way we can escape that? Okay, well, let's under section 43 say, like what I've said about, say, you know, how it's the district court. So actually, strictly speaking, it's the district court that's doing it, even though we all know in practice it's kind of the WRC. So that will get us off the hook. Now, it's not like that they're trying to be bad people or anything like that, you know, but you know what I mean? So O'Donnell says, well, look, basically he says, he doesn't say let's forget about the MacDonald and Bourne-Nagan test. If you read it, and again, I encourage you guys to read the O'Donnell judgment. I cannot stress it enough. But when you're reading it, there's 5 or 6 parts of it that you must read and reread and reread and reread. Okay, and this is one of the parts of it. The history limb, obviously, but in particular, what he's saying about the MacDonald and Bourne-Nagan test. He doesn't say, let's scrap it. It's done. He does not say that. He says something a little bit more nuanced. He says, let's just kind of not regard it as this canonical test, this gospel. Let's kind of just put it there in the background as something that helps us to identify whether or not this counts or that counts as the administration of justice. But let's actually look at it more in the round. In other words, what he moves away from is this empirical checklist box ticking approach, and he moves towards what I'm calling, right, a kind of a walk, talk, quack test, or more an impressionistic test, or another word for it, a more normative test. And by that I mean, should this count as the administration of justice? So in one sense, what he's doing is he's saying it's not about box taking, it's about step back from it, have a look at it. Does it walk, talk, and quack like the administration of justice? If it does, then that's what it is. Then it is the administration of justice. So forget about your little empirical, you know, take a step back. Or another way of looking is that something that, looking at it in the round, feels like it should count as the administration of justice? Because if it does, then that's what it is. So we're moving then, now we're finished the first part of our Zalewski topic. And what we see is that we've moved from an empirical checklist box ticking approach to a walk, talk, quack, impressionistic, normative approach. That's the big change brought about in respect of Article 34 in Zalewski. So I suppose you could say that into the future, for the next 3-4 decades, the Zalewski case is probably going to govern how judges approach this question, right? As to whether or not something counts as the administration of justice. We've now got the Zalewski test, whereas in the past we had the Greyhound test or the McDonald-Bordegon test. Do you know what I mean? Obviously, that's not gone, as I've just said, but there you go. So do you know what, guys? That's kind of the first part. I feel like you guys probably need a little break. So let's just take, let me just stop recording here. Have I stopped recording? Stop share. Stop recording.